Good afternoon, everyone. Again, my name is John Barkley. I'm going to be presenting the Lunch and Learn today on legal issues in starting a business. I am an attorney licensed to practice in California, Texas, and New York. A little bit about me. I am the founder of Barkley Law Group. We are a full-service business and civil litigation law firm. I've been in business for over 11 years now. Before that, I served on active duty. I was an air defense artillery officer in the United States Army. I served at Fort Bliss, Texas, and in Korea. And that's a little bit about me. So here's the agenda for today's Lunch and Learn. I'm going to do a little bit of housekeeping, ground rules, and then we'll talk about the legal steps in starting a business. Then I will move on to trademarks and do just a touch of intellectual property. We're going to talk about lawsuits and dispute resolution, and finally, how to create a win-win relationship with your lawyer. So I had a slide there that was just for First Sergeant's pleasure. So the task: establish Lunch and Learn ground rules. The purpose is to communicate the facilitator's ground rules in order to facilitate an efficient and informative facilitation of learning some of the legal issues of starting a business while eating lunch. For anyone who's watching on the recording, if you're in the Army, then hopefully you get a kick out of that. Should bring back some memories. So at the end of each section, I am going to open it up for questions. I'm going to be doing my best to get through as much law as possible and in the short time that we have. So in order to kind of make that go as smoothly as possible, I'm going to open up the floor for questions at the end of each section and again at the end of the class. If you feel like you might forget, then obviously I've got the chat box open here, so go ahead and put your questions in chat, or at the end of the session, then obviously however you want to do it is just fine. And then at the end of the class, I'm going to open it up to any business law questions, not just the stuff that I talk about here today, but anything having to do with your business. So the only other thing I was going to say is when I open it up to ask questions, this is free legal advice. However, I am not your lawyer, and you're not my client. So the reason I say that is, remember, this is being recorded. So if you start talking about, stuff that's personal, private, it is not going to be protected by attorney-client confidentiality. Now, the last thing I'm going to say is I don't know everything. So I will tell you if I don't know. A lot of times lawyers will give you, it's hard to get a yes or a no answer out of lawyers. There's a reason for that. And that's because we don't know everything, and a lot of this stuff is very, very fact dependent and very specific to any particular case. So, here we go. Legal steps in starting a business. Step one: choosing your legal entity. So there's a lot of stuff out there on the internet about this, and some of it's good, some of it's not so helpful. There's different categories you can fall into: sole proprietor, partnership, or you can go and form yourself an LLC or a corporation. Each one of these different entities has different features, if you will, or different qualities and benefits. Those benefits fall into the four categories, or rather the concerns and or benefits fall into the four categories that you see there at the bottom. First and foremost is personal liability. Forming yourself a corporation or an LLC can help you protect your personal assets from the debts of the business. You enter into a lease, or you take out a loan in the name of the business. You may, just in case things don't work out, you may want to protect your personal assets. The second is income tax treatment. I'll get into the different flavors here in a moment, but different entities come with different income tax concerns and the way that it gets calculated, how much you have to pay. Each one works just a little bit different. And if you've got more than one owner, then you also need to think about sharing control of the business and sharing the profits of the business. And the different entities give you different ways of doing that. So step two, once you pick a legal entity, the next step is to create it. Now, if you're just going to be a sole proprietor, which is just you by yourself, you have to do nothing. You already have everything you legally need. If you've ever worked as an independent contractor, you were a sole proprietor of a business. We are all, in a sense, a business of one, or if you're married, a business of two. And so a sole proprietor, you do nothing. You can, if you want, get an EIN. It can be done for free on irs.gov. Some people will ask you to pay them to do it, but it's pretty easy and painless. You can just go do it yourself for free online. It might be a good idea because sometimes you'll have to give out your taxpayer ID number, and having an EIN, giving it out is better than giving out your social security number. You may need to register a fictitious business name, and I'll talk about that more in just a moment. But if you don't have to register a fictitious business name, then you already have everything you need as a sole proprietor. Again, there's a lot of stuff on the internet about the benefits and drawbacks of each of these entities. So a lot of you probably already read up on a lot of this stuff. But the short version is a sole proprietor, you keep all the profits, you're in control, and you pay income tax just like it's regular income. Except the main difference is that from just collecting a wage somewhere is that you get the pleasure of paying self-employment tax, which is about an extra 7.75% on top of your regular payroll taxes. The next choice is a partnership. So really all you need for a partnership is to make an agreement with somebody. Anytime you make an agreement with someone to do something and split the profits, you have got yourselves a partnership. My two sons, who are 8 and 9, if they decide to have a lemonade stand out front of the house and they decide to split the profits 50-50, they've got themselves legally, they've created a general partnership. Preferably, you put your agreement in writing because if things don't work out, people tend to have a tendency to remember things very differently from one another. Sometimes business partners will remember that the other business partner was going to be responsible for everything, and that they were going to reap all the profits when you might remember it to be very different. Preferably, your written partnership agreement is written by a lawyer so that it has all the bells and whistles and protections that make sure that if there is a dispute, it can be resolved smoothly, predictably, reliably in the right court, and that everyone plays by, has to play fair whenever there is a dispute. And for a partnership, you do have to get an EIN. So that would be kind of the third step for a partnership. Well, it looks like Caesar is coming in. Okay, so if you decide to go the next route, which is to create a corporation, an LLC, limited partnership, limited liability partnership, professional association, et cetera, one of many different flavors of what is pretty much the same thing, where you are creating a separate legal person who is going to own the business and be the business, so that if things go wrong, that other separate legal person, the corporation, LLC, or what have you, is the one that's responsible for the debts of the business, rather than you, the owner, or your investors, if you have an investor. For this, you do have to actually do something. You have to file documents with either the Texas Secretary of State or whatever state you are going to be operating in. The next step is to draft and sign documents such as bylaws, your company agreement, etc. The name of the document and how many documents. You can see this is a pretty typical stack here on the right-hand side of corporate documents. No, not really. It's not quite that bad. But in any event, the name, what they're called, and how many you need really depends on your choice of entity, and you know what kind of features you want that entity to have. And then lastly, get an EIN, just as with the other ones. So then step 3 is to follow the rules you choose. Now that it's going to either be your corporate bylaws, your partnership agreement, your LLC company agreement. Again, depending on which flavor of entity you choose, it's important to follow the rules that you choose, because that liability protection, where the business is responsible for the debts of the business, or excuse me, if the corporation, partnership, or what have you, if that other legal person is responsible for the debts of the business rather than you, in order to maintain that, you need to follow the rules that you choose. And that includes doing your meetings, doing your shareholder meetings or LLC member meetings or what have you, following the rules with regards to voting on managing the business, and giving notices. All these documents, assuming that an attorney's prepared them, is going to have provisions that cover each of those things, and it's important to follow those rules so that you keep that liability protection instead of going through all this work and time and effort and then losing that liability protection for you. Step 4 is kind of the rest of it. So fictitious business name. So this is something you file with the county that you're operating in. Each county that you operate in, you should file your fictitious business name. Every county has its own form that you fill out and file. You pay a small fee, and then check the box. You are done, and you've got your fictitious business name. The exception to this is if you're using your own name. So, for instance, Barkley Law Group. I don't need a fictitious business name filing with Montgomery County because I'm using my own name. This goes for lots of, obviously professional firms, accountants, lawyers, maybe even doctors' offices or insurance agencies. Lots of professionals who are doing that kind of one-on-one dedicated service. They use their own name, and they probably don't need a fictitious business name. But if you're operating a business, for instance, if I was going to change my business from Barkley Law Group to, say, Bankruptcy Law Center or Conroe Law Firm or something like that, where I'm not using my own name, then I would need to file a fictitious business name statement with Montgomery County. Obviously, open your bank accounts. The last thing that I've got on the list here is when you are signing contracts, it is important to use your business name, especially if you've gone to all the trouble of creating a corporation or an LLC. If you sign that lease in your own name, then it doesn't matter if you created an LLC or a corporation. You are ultimately responsible for that lease, whether things work out for the business or not. So it's important to make sure that when you sign contracts that you get the business name on the contract. You'd be surprised how many times this simple thing goes wrong and kind of bites people in the end. Kind of one thing one caveat on here is, especially if you're first starting out, you got a small business, not much of a track record. Your savvy business folks out there will ask for personal guarantees, meaning that if you have created your entity, they're still going to ask for you to be personally responsible. It's important to remember that this is pretty common. You don't have to say yes, but particularly with leases and your bigger contracts, and especially large loans, it's going to be kind of par for the course, and you just got to make sure that you've weighed the risks or making a good business decision there. So that's kind of it for the legal steps in starting a business. There's not much to it. As I said, we are all already a business of one. And so there's not really a whole lot to starting a business legally. So are there any questions on section 1?
Hi, my name is Lena Shake Snyder. I have a question.
Go for it.
So, I'm just not realizing I have a LLC and a nonprofit, but with my LLC, I didn't do, it's small, so I didn't do like corporate bylaws. So do I need to do that myself, or should it be best if I go to get a legal team to do it for me?
Okay, so really there's 2 questions there. I'm going to take the first one first. So it sounds like you formed an LLC, but you didn't do like the operating agreement or any of the other documents that I kind of mentioned in there. Is that right?
Right.
Okay. As long as it's just you, one, you're not breaking any laws. Okay, so rest assured that you're not going to get in trouble for not having a company agreement, as long as you're the sole owner. However, it is still a good idea, even if you never get another owner or if you don't have another investor, it is still a good idea. If you do not have an operating agreement, many states, including Texas, they have some default rules built into, whether it's the corporations code or whatever statute, whatever the name of the statute is in the various states. They do have some default rules, but you really ought to go out and get a company agreement. For an LLC, all it is a company agreement. That covers, that kind of encompasses multiple documents. Whereas in a corporation, there would be multiple documents that would kind of discuss the same things as an LLC operating agreement. Same thing goes for your nonprofit. It's kind of, if you haven't done it already in the nonprofit, it's actually more important in nonprofit. And if you're filing, if you have filed for a 501c3 registration with the IRS and it's required, the IRS, if memory serves, I think the IRS actually requires either a copy of the bylaws or they want to see portions of your bylaws for your nonprofit. So that's kind of the first question. The second question was, should you go out and hire a lawyer or a legal team to do it? It's certainly better to do it that way than to simply get something off of the internet. You can go to places like, there are websites that's what they do, and it's not cheap. It's probably less expensive than hiring an attorney. But that really kind of depends on the attorney, and what how competitive they are. So I certainly don't recommend you try to do it yourself with something that you find off of Google, or just something you pull for free off the internet. I do recommend you actually go somewhere to whether it's an actual lawyer or one of the websites that specializes in preparing these things, and get your document there. Great question.
Hey, John, can I ask you a question real quick?
Sure.
This is Caesar. Since several of the business owners are working on nonprofits, I'm wondering if you know of anything around in Montgomery County. In Houston, they used to have something called Texas Accountants and Lawyers for the Arts, TALA, which would, when I started my nonprofit in 2004, represented me free. As long as the money that you brought in was less than a certain amount a year, they would represent you for free, with your articles of incorporation, your LLC, your nonprofit incorporation documents, and they would also be the business of record. If you didn't have, for instance, a place of operation yet, they would house your documentation so that you were in compliance with all of the requirements for people being able to have a public place to access your documents. Do they have anything like Tala? Does that still exist? This was a long time ago for me. Do they have anything like that that still exists? And is there anything in Montgomery County?
Not that I'm aware of. Again, I moved here about 3 years ago, so I'm still relatively new to Montgomery County myself.
Okay.
So no, I'm not aware of anything like that. My firm does it. I mean, we're not free naturally, but yeah, in terms of a resource like that, I'm afraid for nonprofits specifically, no, I'm not. But there probably is, you know. If not up here in Conroe, then there's a pretty good chance there might be something like that in Woodlands. So you know, it's pretty. I mean, it's not Harris County, but it's a pretty big county. You know, there's lots of people here, so there would be certainly a need for something like that.
Okay, we'll look into that for them. The Tala used to be housed out of. It was right next to the Menil Museum or the Menil Collection in Houston. And they would represent both like artists, musicians, nonprofits. The cool thing about it was that it was kind of an all-in-one resource. So they provided support for both accounting and legal services. So right after they represented my nonprofit, we licensed some footage to Telemundo. They didn't pay the licensing fee, so they, gave me a lawyer pro bono who was actually Rochelle Joswick, one of the chief lawyers for Exxon at the time, that was just doing it as a pro bono side project. And they got me my money within a week and actually got double what the licensing fee was. So it was, I'm hoping we can find some kind of a resource like that for them as well as they're starting up. It was cool to have the accounting and the legal in one nonprofit organization that would provide both for you.
Yeah, and for a nonprofit, you know, the accounting is, proper books and doing good accounting is important in every business, but it's kind of even more so for nonprofits, as I'm sure you know, because, you know, in a nonprofit, a lot of times, a lot of times you are working and dealing with other people's money. So, you know, it is important whether there is still a free resource like that or not. You know, the folks who are doing nonprofits, it would be very, very good idea to find, you know, to make sure that they've got those resources at their fingertips. You know, whether there is a free resource out there in Montgomery County or not. You know, it's certainly the sort of thing that needs to be done right.
Thanks.
All right, moving on to section 2, trademarks and intellectual property. So I'm going to start with trademarks, and then I'm just going to do a very brief section on intellectual property, because these are things that are, well, trademarks have always been important, but intellectual property obviously has gotten to become more and more and more important, pretty much exponentially over the last 40 years. So trademarks, I'm going to talk about what they are legally. For some examples. What they do for your business. What you need to do to get trademark protection. And things that can or cannot be trademarked. So what are trademarks legally? They're logos, shapes, names, colors, sounds. It's anything used to identify the source of goods or services. Obviously, Coca-Cola is a trademark. American Airlines is a trademark. My little logo that that I made 11 years ago using Microsoft Word is, you know, it's technically is a trademark. What they do for your business, well, they serve two purposes, which is the reason that the law provides protection for trademarks. One is that they let customers know that they're getting the real deal. If you walk into a store and you buy a bottle of soda that has Coca-Cola on it and you drink it and it's obviously not Coca-Cola, then Coca-Cola has a cause of action. It's got a the right to sue whoever is making that counterfeit Coca-Cola. And that's the other side of it, is that trademark law allows you to protect your investment in your branding, in the quality of your goods and services. If you're out there making high quality goods and doing or providing valuable services and making a name for yourself, then you deserve to not have someone else come along, a faker come along, and be giving out or selling counterfeit goods and services. The other thing it does is, if you, especially if creating attractive brands, attractive names, slogans, logos, things like that, is that it will attract customers. And you want them to be attracted to you as opposed to a competitor. So what do you need to do to get trademark protection? Well, the most basic form of trademark protection, the common law trademark protection, all you need to do is use it. You need to slap that logo on your box or on your product or on your website. You need to, put that slogan in your advertising. All you have to do is use it, and you get trademark protection. One of the reasons I have this airplane over here, it's a little bit confusing because at the front it says American. It's an American Airlines airplane, but on the back it's got this. It says PSA. PSA used to be an airline. When PSA was an airline, those little letters in that stylized form was a trademark. Well, it still is a trademark. Those are PSA's colors painted on the side. And if you look real sharp, you can see a smile painted on the nose of this airplane. That was a trademark of PSA, which again used to be an airline. So what in the world is this doing on an American Airlines airplane? Well, PSA was bought by US Airways. US Airways was bought by American Airlines. If US Airways had stopped flying a plane, if they had stopped using those trademarks, they would have lost the right to protect those trademarks. Someone else could have started another PSA, put a smile on the airplane, color it the same colors, and everyone who lived out in California would probably think it's the same old PSA. But since this is just one airplane, I mean, you don't have to use it all over the place. It's just one airplane, but so American Airlines flies this plane around in order to maintain those trademarks. So you have to use it. As soon as you stop using it, your protection starts to go away. You get a little bit of a grace period after you stop using it. But if you stop using it and you're not using it anymore, it's not yours anymore. I actually recently had a client where they had designed, they found someone, it was a sort of a competitor. They were a marketing company, and they found a competitor in Nigeria who had essentially copied verbatim their entire website, but it was their old website. And I told them, I had to advise them. I said, well, look, this is your old website. It's pretty clear that they just copied it, but your protection on that old website went away as soon as you stopped using it. Now, if you want nationwide protection, you do need to register your trademark with the U.S. Patent and Trademark Office. There's an online form. You pay a fee, and you go through a little bit of a process, and you get nationwide protection. So that sort of begs the question, well, what's the other one good for? What's common law good for? Well, common law trademark is only good for the area that you're in. So if you're operating a restaurant and you name it Chili's, that trademark is only really good for your city, your county. However dominant you are in your market, it's really only good for your area. But if you register with the trademark office, it is good nationwide. Which kind of brings me to the next topic. Sometimes you'll see the TM symbol next to things, and sometimes you'll see the little R inside of a circle. The TM means anyone can put a TM next to their trademark. All the TM is doing is it's kind of a warning or a notice. It's putting everyone on notice that you are saying that this is your trademark, and if anybody copies it, then you'll have a problem with that and might sue them over it. In order to have the right to use the R, you do have to register with the trademark office. So when you see the R inside of the circle, that's going to carry more weight. So some things that can't be trademarked: generic words. It's like soda. A generic word is one that describes what the thing is. Airline cannot be trademarked. Soda cannot be trademarked. Law firm cannot be trademarked. Reason for this is pretty straightforward, because other people need to be able to make soda too, and other people need to be able to have airlines as well, or law firms. You can't trademark things that are merely descriptive, such as tasty soda, reliable airlines, ruthless law firm, because again, everyone needs to be able to describe their products and services. And of course, if it's something deceptive, if you can't call something California wine if it's coming from Nevada. Things that can be trademarked, well, words that can be trademarks, they fall into arbitrary, fanciful, and suggestive words. Arbitrary it's a real word, but it's got nothing to do with whatever the product or service is. Some good examples of that is Apple computer. Apples really don't have much of anything to do with computers, so that would be an arbitrary one. Other examples are Amazon or Excel, as in Microsoft Excel. Really, the word Excel really doesn't have a whole lot to do with spreadsheets and calculations. And of course, Amazon didn't really have much of anything to do with selling books, which is what it started off doing for those of us who can remember that far back. The next kind, fanciful. These are just made up words. So Kodak is kind of the classic example of a fanciful word. The last one is suggestive. So Chili's restaurant I just mentioned, it kind of suggests what it's about. Chili's. It's kind of, you kind of get the idea in your head as to what it is. My favorite though is Tesla, since Tesla was a famous inventor who invented a lot of things having to do with electricity, and Tesla, of course, makes electronic cars. So that's trademarks. I'm not really going to get into patents and copyrights. There's just too much there. Patents are generally for inventions. There is such a thing called a process patent, but patents is your inventions. Copyrights is more for creative stuff. Writing a song, you're going to be looking at copyright protection. Writing a book. Interestingly enough, computer code falls under copyright protection instead of patent protection. So for anyone out there who's going to be doing software development, then copyright would be what you'd be most interested in. The one I am going to kind of touch on is trade secret, because even though not every business is going to be getting patents or registering copyrights, pretty much every business does have trade secrets. Trade secret is something that has economic value. It's not generally available, and the owner has made reasonable efforts to maintain secrecy. So some of the best examples of this is recipes. The 11 herbs and spices, the famous 11 herbs and spices at KFC. Colonel Sanders didn't go out and get a patent on it, because when you get a patent, you have to show the world how it works. You have to let everybody know exactly what that recipe is. And so it's probably better to keep it a secret, since patent protection runs out. Trade secrets can last forever. The other famous recipe that's a trade secret is the recipe for Coca-Cola. But other businesses, especially professional businesses, customer lists. Even though people's information might be publicly available, you might be able to look them up in the phone book, your list of customers or prospects is valuable, because those are people who are ready, willing, and able to purchase your service. Wouldn't it be great to have a list of our competitors' customers so that we could maybe call those people up and let them know that we can do a better job. But so that's something that you will want to protect. Sort of the reverse is true. Your vendor and supplier lists, wherever you get your low cost ingredients or the best ingredients or the best parts for whatever it is that you're doing or building or selling. Business methods and market research can also be trade secrets. So these are the things that you will want to protect. You will want to, and it's not hard. I'll get into that next. But these are the things that you will want to protect and make sure that they stay in your hands as opposed to getting into the hands of a competitor. So what do you get when you have a trade secret? Well, if it does get out, then you can sue whoever it is in court. You can get an injunction, which is a court order, an order from a judge telling them, prohibiting that competitor from using your trade secrets. And you can also get damages, whatever your lost profits are, or any other monetary damage that you suffer. So what do you have to do? Well, it is pretty simple. And many businesses do this anyways. Non-disclosure agreements, or you have terms in your contracts that says that things are, some of these things are going to be confidential and they have to be treated as confidential. You can mark your documents. You can mark things as confidential. That's another easy way of maintaining secrecy. And then, of course, controlling access. And for those of us in the military, who have been in the military, this should come relatively intuitively, controlling physical access. When we had our classified materials, we kept them in a safe. Computer access, just having passwords, logins, making sure that if someone comes in or someone leaves your company, you terminate their logins. Just staying on top of all that, which you should be doing anyways, but it all kind of plays into your trade secret protection. And then separating information amongst employees. In the military, we called it need to know. Not only did you have to have a security clearance at the right level for viewing whatever the classified material was, but you only got to look at it if you needed to look at it in order to do your job. So that's my section on trademarks and intellectual property. Do we have any questions on those?
Hi, me again, Lena. I have a question. Okay, so I already applied. I went through a lawyer to trademark my logo and the name of my company. But I had a question about, I haven't gotten it back. It's been a while. I don't know if it's because of COVID and I don't know how long the process takes, but my lawyer, I kind of like periodically check up with her. But the question that I have is that I do t-shirts, right? I put positive quotes or like come up with positive thoughts that's funny or humorous to help like improve people's day with that suffer with PTSD. And so the question that I have is, do I have to trademark every quote? Or could I be like, how does that work?
Well, when you're talking about, okay, so there's kind of two questions there. First is about about where you're at in the process. So I'm gonna pull a typical lawyer move and answer your question with a question. About how long ago did you get this process started?
It's been since I started the t-shirt thing in 2018. Like I started.
I mean the trademark itself. When you did
the trademark. It was 2019.
Okay, something should have happened on it by now. Let's see here.
Like when I type in my business information, if you type in the name of my company, it shows that it's a trademark pending, like something like that. If that makes sense.
Yeah. Let's see here. I mean, I'm not necessarily going to like start. I'm not going to dig into the trademark system right now, just because I don't know. Since I don't know your lawyer, and I don't want to necessarily say or do something in order to that would interfere with that relationship. But the process, if it goes smoothly, the process should take about 6 months. COVID, the impact of COVID, if it slowed it down, it slowed it down by a month or two. It's so that is probably not what the issue is. I've filed a few trademarks even during during kind of this COVID period, and I didn't notice any real meaningful difference in the processing time. So I'm not sure what's going on there, but there is some other issue there. Now, your second question had to do with, do you need to trademark each phrase or each slogan or anything like that on your shirts? The trademark office actually won't let you do that because the slogans they call it a design element of the shirt. In other words, it's again, trademarks are supposed to identify the goods or services, or the source of the goods or services. So, if you've got the name of your company or your nonprofit on there, then that could get trademarked. But like the designs itself, if the trademark office looks at the slogan or whatever it is and thinks it's the phrase or what have you, if they look at it and they think it's part of the design, they will not let you trademark that. So,
John,
you don't have to go and trademark all that stuff.
Okay,
John, a quick question on that, just for clarification, because I think I don't know if this is what she's referencing, but you have celebrities like Paris Hilton who got a trademark on a catchphrase, which was "That's hot," and she's applying for a new patent. Maybe she got it on the word "sliving," slaying and living. So my understanding before she did that was always that if it's sort of a catchphrase, it's general language, it's not specific to an image or logo or something like that. I didn't think that you could get a trademark on just a general catchphrase like that, but then she did, so I was a little bit it doesn't really matter in my business, but it was a little bit odd and confusing to me. So if she were to have t-shirts like this, and maybe there's a recurrent slogan or logo phrase that they use frequently, would it be kind of a Paris Hilton's situation where she could do that?
Yeah, that would be different because that's become a slogan,
Okay.
and so a slogan is, that's what a slogan is for, is so that people remember it and they remember the source of the goods and services. And so that is a little bit different. And so that's what was going on with Paris Hilton. Now, in terms of the second one, what was that, sliving or something like that?
Yeah, that's what she's applying for a trademark on now, is the word sliving. Which
so that's kind of an easier thing, because that's a made up word.
Right.
So that's kind of an easier analysis, I guess.
Yeah.
But
that's what I thought.
Good questions though. So if you get a slogan, that is a different thing. But if you're having sort of these messages, and that's kind of what they're about, then the trademark office is probably not going to let you trademark that, and there wouldn't be much of a point in spending the fees, which the fees aren't cheap. The filing fees with the trademark office are not cheap. So you wouldn't want to be spending your money on that.
So is that the situation with like a lot of the t-shirts that become so the Let's Go Brandon t-shirts that are very popular, and you see a bunch of different makers using that same slogan? Is that a matter that somebody, it wasn't iconic to a specific brand or individual, so it couldn't be trademarked, and therefore anybody can sort of put that phrase on a shirt and sell it?
I would have to say probably. I'm not familiar with those shirts or anything like that, so I don't know. But yeah, probably.
Okay.
The key is that the trademark is meant to identify a specific maker. Whereas, if it's a slogan or something that makes you want to buy it because you like that's the way I would think of it. Is if it's a slogan that you put on there because somebody's going to want to buy it because they think it's clever, or they think it's fun, or they think it's whatever, there's something about it that they like, then that's probably a design element, and you probably cannot trademark that. If it's something that is specific and specifically identifies you, or you use it in your advertising, promotion, then that is not a design element, and that might be something you can get trademarked.
Okay.
Excellent. All right. Lawsuits and dispute resolution. So first, we're going to talk about lawsuits. We're going to talk about what are lawsuits and how can lawsuits make you a better person. All right, and then dispute resolution, which I also call how to save time, money, and heartache while still becoming a better person. All right, so what are lawsuits? What are they? How can they make you a better person? This is how most people feel when they think about lawsuits. They feel like the guy on the left, and they feel like the person suing them is the guy on the right. So what is a lawsuit? A lawsuit is, well, it's our society's the best thing we've been able to come up with for resolving disputes. It's the last resort for resolving a dispute, and so yeah, you go through a process. Now, back in the cave people days, if you had a dispute, you went over to the other cave person's cave with your club, you knocked them out, and you took their stuff. But we live in a civilized society. You're not allowed to do that. So what we do have, though, is if you play your cards right and you follow the process and you file a lawsuit, prove your case to a judge and maybe a jury, then you get a judgment. And with your judgment, then the sheriff goes out to the person's place and starts taking their stuff and sells it and gives you the money. So what to do now? What I'm going to talk about next, as business owners, most of the time what we're concerned about is getting sued, unless you are a lawyer, in which case you are looking for people to sue. But what I'm about to tell you is advice that is good for whether it is you who have been threatened or have with a lawsuit or have been sued, or if you're on the other side and somebody has done you wrong, somebody has either cheated you in business or committed fraud against you, destroyed some of your property, and they're not doing the right thing, and they're not stepping up and making things right, you may have to ultimately sue them. So what to do? One, hire a lawyer. In some cases, you are allowed to represent yourself. If you have a corporate entity, you are not allowed to represent your corporate entity unless you're a lawyer. But the lawsuit process is, one, it's very complicated. There's lots of things that can go very wrong if you fumble on the rules. Two, it is a tremendous amount of work. There's a reason that lawyers bill so much on lawsuits, and that is because it is a tremendous amount of work. So you will want to hire a lawyer. So the second thing is expect to spend money, especially if you have been threatened with a lawsuit or are getting sued. Expect to spend money. I generally tell people that, ballpark, in order to get a case to trial, minimum, including experts and filing fees and service of process and all the stuff in the middle, as well as paying your lawyer, expect to spend at least $50,000. That's on a straightforward, simple lawsuit that does not have a whole lot of other parties involved, doesn't require a lot of investigation or multiple experts or anything like that. And that's also assuming that the other side is relatively cooperative and is not what they call a vexatious litigant, excuse me, who is essentially a vexatious litigant is somebody who just they either bend the rules, break the rules, whatever, in order to just give you and your lawyer a hard time. So assuming that it goes smoothly, expect to spend at least 50 grand to get to trial. If you are on the other side and you are suing somebody, you might be able to find somebody who works on contingency, as in a lawyer that works on contingency, but then you might be giving up part of that award, part of your, the justice that you're getting. Part of that's going to be consumed in paying your lawyer. Next thing is expect the other side to lie. So this is why I say when you do contracts, when you do agreements, yes, in most cases, an oral agreement is legally binding in most cases. An oral agreement is legally binding in most cases. However, when things go wrong, people remember things very differently from how you might remember things. And you can expect the other side to lie. I've been in many lawsuits, obviously. It's about half of what we do here for a living. And it's just what happens. Now, in their mind, they're not lying. They just remember it differently from you do. But it's definitely going to feel like they're lying. Next thing is stay off social media. Does anybody know who's in the picture?
50 Cent.
50 Cent. That's right. And it's kind of hard to see, but what's he got next to him?
Money.
He's got stacks upon stacks upon stacks of $100 bills. I don't know. It looks like at least probably a couple $100 grand. And it is kind of a little hard to see, but he spelled the word broke in it. Does anyone happen to know what was going on in 50 Cent's life when he took this picture?
He filed bankrupt?
He was in bankruptcy, and he put this picture on social media. He put it up on Instagram. And the bankruptcy judge had some questions for 50 Cent, since, of course, when you go to bankruptcy, the whole idea is you're saying to the world, I've got no money, I've got all this debt, come help me out. And the law does provide for a mechanism for a fresh start called bankruptcy. But if you do have assets, then the bankruptcy trustee is supposed to seize those assets and use it to pay your creditors. So 50 Cent had to explain himself. He had to explain why he's in bankruptcy and he's got all this money. And of course, everything worked out in the end. He explained, well, it wasn't his. He was just holding it for somebody, and so it really wasn't his, and so he doesn't have to turn it over to his creditors. So this is kind of a funny sort of example, but there's lots of other examples, including in some of our cases that we've had, where people cannot help themselves. They get on social media and they start saying stuff. They say something about the case. You can believe that when there's a lawsuit going on, especially, your social media is being watched. And even if you put something up and take it down the next day, a screenshot a screenshot takes about 3 seconds, and that screenshot can, of course, last forever. So stay off social media if you are involved in a legal dispute. Every lawsuit's different. They all turn out different, so it's really kind of is a case-by-case sort of thing. So I can't get into a whole lot of detail there, except that, it's hire a lawyer, listen to your lawyer when you've got a legal dispute going on, and expect it to take. The last thing here I want to say is they do take quite a long time as well, or they can take quite a long time as well. So dispute resolution, it's always better to resolve the dispute before a lawsuit is filed, no matter which side you're on. If you are the aggrieved person seeking justice, or if you are the victim of a frivolous lawsuit, it's always better to resolve it before before it gets that far. So now business disputes, they can involve customers, employees, suppliers, the government, of course, especially if you don't pay your taxes or if you don't have the proper licensing, or any of those other things that get heavily regulated. And of course, competitors, especially if they're stealing your trade secrets or using your trademarks. And of course, everybody else. So steps to resolve a dispute. First and foremost, get ahead of the problem. As my first battery commander told me, bad news is like moldy cheese. It does not get better with age. If you have a reason to think that there is going to be a problem that can turn into a legal dispute, and a lot of them do, or a lot of them can, don't ignore it. I guarantee, especially if it's somebody who feels their feelings are hurt or they're upset, they are on the move. They are maneuvering themselves, and they are, collecting their evidence. And you need to not ignore the problem. Probably call your lawyer. It says here, an ounce of prevention is worth a pound of cure. I think in my experience, it's more like a metric ton of cure. Call your lawyer. It's going to be cheaper to have that telephone call and get a solution right away than it is going to be to pay, $50,000 or more to defend a lawsuit. Generally, it's okay to talk to the person. But when I say talk to the person, I'm not saying talk to them and tell them why they're wrong and why you're right. I'm saying talk to the person to listen to them. People want to feel heard. A lot of times, I've dealt with many situations where we talk to the person, we listen to the problem, explained what happened or what went wrong, and the person understood. And since they had felt heard, we figured out a way to try to make it right as best as we could. And the person felt heard. If you kind of let the steam out, you kind of let them blow off steam to you privately instead of on social media, or instead of to a plaintiff's lawyer, or worse, So talk to the person. People want to feel valued. They want to feel heard. This works especially well with customers, with employees. It's not going to work so well with the government, but certainly with most people, that will go a long way to solving your dispute. Next is make a tentative plan. So educate yourself, or either educate yourself on your own or listen to your lawyer about the possible outcomes, no matter how worthy or just. If you do have a lawsuit or a legal dispute, and you don't do what you need to do in order to get it resolved, or you don't do what you need to do in order to defend yourself, things can go horribly wrong, no matter if you're in the right. So you do need to educate yourself so that you can make a plan. You need to figure out ways to reduce the chances of getting sued, or reduce the amount of damages someone could recover in the event that you are sued. So that's real specific, or that's really very much a case-by-case basis. So I'm going to tell a brief story to kind of illustrate this. I had a client who I'm going to change some of the facts in order to protect their confidentiality. I had a client who made stuff, and they had an employee who was not a good employee, and they often were late, or they would call out multiple times a week, and it disrupted everyone's lives, especially their fellow team members, and it disrupted this company's ability to deliver a quality product to its customers. So they just weren't a good employee. So the company, the manager calls me up, or rather, I think they wrote an email, said, "This is what's going on. I want to let this person go." And I read through it and I said, yeah, I think this is, I think you're in the right. You don't, go ahead and terminate the employee. So after they terminate the employee, they call me up and they say, I sent them an email saying, hey, how'd it go? So they call me up and they say it went really well. The person kind of knew that they were on that they weren't going to last much longer. They were actually interviewing for other jobs already, even before I let them go. And I let them know that it had nothing to do with the OSHA complaint that they had filed. And of course, I say, what OSHA complaint? Because for those of you who don't know, if somebody files a safety complaint with the United States government, you can't fire them because of it. Otherwise, you are in big trouble. Well, lo and behold, the person filed a whistleblower complaint with OSHA, and I told that company immediately offer them their job back. Why in the world would we offer them the job back? Well, the reason I made that recommendation, and they did, they followed my advice, is because when you let somebody go and when you wrongfully terminate somebody's employment, not only are they entitled to recover their lost wages from the time you fire them until the time they file a complaint, but they're also entitled to recover it out into the future as well. Now, how far into the future, that's something for judges and juries to decide, and for lawyers to argue about, and for you to have to pay your lawyer to argue about. So by offering this person their job back, we got rid of that future. We got rid of the future lost earnings, because from the moment that they got that offer, it was their own fault for not having those future lost earnings, because we offered them their job back. So we cut off, you stop the bleeding, you mitigate the damage, and that's why you kind of want to get out in front of these things as quickly as possible. That one we wound up offering 2 weeks pay. Person accepted it, and that was the end of it. Again, expect the other side to lie. And of course, stay off social media. Lastly, communicate with the other side. And again, this sort of serves three purposes. One is to let them blow off steam. And it's also so you can gather information, both to defend yourself eventually, but also to try to correct the problem, which is actually the best possible outcome, is to correct the problem. Give the person a chance to vent their emotions, and of course, actively listen. So, nope, not that one. The last one is put your emotions aside and make the best decision for the business. It was a pretty tough pill to swallow for that company to offer this person 2 weeks pay when that person was a bad employee to begin with. They deserved to be terminated. And the OSHA complaint wound up being bogus too. And so it was obviously a very toxic person. It was a real tough pill to swallow, but they made the right call in offering that money. It was going to cost them way more to pay me to defend that case, even if they won, than it was to go ahead and make that offer. So you got to put your emotions aside and make the best decisions for the business. If it doesn't make dollars, it doesn't make sense. All right, so questions on lawsuits and dispute resolution. The next section is real short for those of us or anyone who's getting tired of hearing me talk. So questions on lawsuits and dispute resolution.
It's really good. I think you have great advice there, John. I tell you, one of the things I think we have trouble with is just sitting down and listening to people, especially people, we find argumentative, or maybe we don't like their opinion. But I'll tell you, as a business, multiple business owners, when I was younger, I get mad at people and threaten them and all those type of things. And, you end up talking to lawyers a lot. And as I got older, I learned if you just keep your mouth shut and say, I'm here to listen and take notes, and, at the end say, I hear you. You don't have to agree with them, but you say, I hear you and I understand your concern. I can't tell you how many complaints or threats I got taken away just by willing to listen. And I think, and then you have a good lawyer like yourself who's sitting next to you, you know, giving you excellent advice. I think it helps so much, you know, but it's not easy. I think what you do, and especially our business owners, what they do, it's not easy to kind of put your emotions aside, but you need someone, a third party like yourself, to help them, because it's easy to get fired up. You know what I'm saying? It's you see the guy not working and then he's, you know, bad mouthing you. It's really easy to get fired up. So I appreciate this. Very good advice. So
Thank you. Yeah, and just to kind of dovetail on that just a little bit. Yeah, as a business owner, I mean, not only is the business a source of income and how you support yourself, your family, and enjoy life. Not only is it that, but it's like it's a part of your identity. So it's very easy and natural, I think, when somebody makes a threat against that business, for us to take it personally. It's a very, very, it's a deeply personal sort of threat, and so it is challenging to put those emotions aside, and obviously, and everybody's different, and has different levels of self-control. But on the one hand, veterans can be very disciplined people, and do know, or at least have had experience in putting emotions aside and doing very difficult things. But at the same time, I think veterans can be very passionate. So it might be, we have a different set of tools, but at the same time, we also, have maybe a different level of confidence. So in when it comes to conflict. So in any event, yeah. All right, so the last section, creating a win-win relationship with your lawyer. So I'm going to just briefly, what is a lawyer, and how to get what you need from the attorney-client relationship. So a lawyer is a person went to 3 extra years of school after college and passed a bar exam lasting 2 to 3 days, has skills in reading and interpreting laws, rules, and regulations, and a person who trades time, knowledge, and skills in exchange for payment of money. A lawyer is not an all-knowing source of legal knowledge and information. So there you go. How to get what you need from the attorney-client relationship. First, be honest. Tell me the good with the bad, and tell me the whole story. This saves a lot of time. You're going to get better advice, and we can solve the bad. We can solve problems before they get worse. And that is where you're going to save money, both in legal fees and also in, all the other costs and problems that go along with, with legal issues. The second thing is ask questions. Don't be afraid to ask questions. It might, it might cost a little bit to pick up that phone and call your lawyer, but you are, assuming that you have a good lawyer, it will be well worth it. And ask for help. The reason I say ask for help, lawyers have actually we have a lot of rules. We have a lot of professional ethical rules, believe it or not, that are actually law. And so if we break those rules, we either get disciplined by the state bar, or we can actually lose our license. So there's lots of rules. As lawyers in general are cautious, risk-averse people, believe it or not. A lot of these rules discourage us from being proactive. If I see a problem in a business, or if I see a legal problem in a business, it's easy, or it's common, or the kind of normal way of thinking for a lawyer is not to fix it unless we're asked to fix it. So that's something to keep in mind. Ask questions, ask for help. That's kind of the first thing. And the saying I use is, like vampires, lawyers have to be invited in, which most people usually like that comparison, or at least, you know, find it appropriate. So if you're worried about cost, ask, ask questions, ask what it's going to cost, and don't be surprised. If you've got a legal issue and you have a good lawyer, the lawyer is going to know approximately how much work and time and energy it's going to take. And so, what might be a simple thing might actually turn out to be, what you might think is a simple thing might actually be pretty complicated. People will, folks will come to me and say, well, we're putting together this business deal. We don't want a lot of paperwork to it. We don't want anything too complicated. And then they explain the business deal to me. And in my head, I'm thinking, this is going to take at least 40 or 50 pages. If you've got a decent attorney, the lawyer is not going to make things complicated. Creative entrepreneurs make things complicated. So, but again, listen to that advice. If you've got a deal and it's going to make you a ton of money, do it. But make sure that you are covering yourself and having it properly documented, and don't be surprised about the cost. And that goes both ways. Whether it's something and you think you're worried it's going to cost like 10 grand to get something put together, and it winds up costing a few $100. Don't be surprised. It's just we know we kind of have an idea of how much work it's going to take. Now, if you feel like it's too much, then get a second opinion. Obviously, go find some other lawyer. Last, follow your lawyer's advice when it comes to the law and legal disputes. Everything else, use your own best business judgment. But when it comes to the law and legal disputes, follow your lawyer's advice. That's how to get what you need from the attorney-client relationship. So that's the end of section 4, creating a win-win relationship with your lawyer. And are there any questions on that?
I thought it was great. I think people, they don't understand, it's weird. It's just like, people don't understand that lawyers are people too. So
allegedly,
yeah, and it's like, it's a two-way relationship. So if you're willing and supportive, it works both ways, lawyers, of course, they want business. People also don't know, and I'm not saying this for you, but they don't know you can negotiate with a lawyer, that you can maybe not reduce their costs, but say, look, I have a lot of business. You need a lot of people to help yours. We can find ways to, work together, because like my business is growing and your business wants to grow. So there's other things that we can do to create value for each other. And I think we forget that. We see it as a very limited relationship, where it can be a mutual partnership, and it can be a mutual growth partnership where you work together to grow each other's businesses and opportunities. So I think this really brings light to that, and I really appreciate that. That's really great, John.
Yeah, and you bring up a couple of really good points. We are running a business too. We have staff, we have bills, we have expenses. We do everything that you guys talked about in this throughout this entrepreneurship bootcamp. We do those things. Creating the relationships. Lawyers are historically horrible business people as a group, but we do our best to do all of those things just like any other business. So, you can get other kinds of advice too. I've had relationships with clients that were superb, and I've had relationships with clients that cost the client a lot of money. Because if they're not upfront, or if they, then there's a lot of work to scramble to fix a problem late in the game. That's it. And I mean, if somebody lies to me, or if somebody doesn't pay the bill, yeah, they're gone. They're not going to be a client anymore. Or if they're just, a jerk, then yeah, they're not going to be a client anymore. But But if they, you know, the best clients that I've had, the ones I really enjoy working with, aren't the ones that get the big bills. It's the ones that call me, the ones that we get in front of the problems, and they, you know, it's not free, but it's certainly cheaper than the other folks. And they have healthier businesses as a result. They have, you know, better relationships with their employees and suppliers. Sometimes those relationships require barriers, and I'm a part of creating healthy barriers for employees and customers and suppliers and competitors and things like that. And those are the best clients, the ones that have, you know, the small bills, because they get ahead of stuff and they're proactive about things.
Absolutely. Absolutely. Okay, Jen, I'll have to cut you off there. We're going to have to, we have one last section we got to finish up, but I appreciate it. Thank you. Thank you very much for everything. We're going to take this video and blast it out to everyone. There's a few people who weren't here today. We'll blast it out to everyone, but I really appreciate the great work you did, John. I look forward to seeing you on Saturday.
All righty. Thank you.